People v. Augustin Morel, decided on February 17, 2026. Rivera, J. The issue on appeal is whether the accusatory instrument, which charged defendant with driving while his ability was impaired by marijuana, is facially sufficient. We conclude that the factual allegations of defendant's recent marijuana use, his physical manifestations of impairment, and his refusal to take a drug test provide reasonable cause to believe he committed the charged offense, and we therefore affirm. Defendant Augustin Morel was charged by misdemeanor information with driving while ability impaired by drugs in violation of Vehicle and Traffic Law, Section 1192(4). Under that statute, no person shall operate a motor vehicle while their ability to operate such a motor vehicle is impaired by the use of a drug as defined in this chapter. Vehicle and Traffic Law, Section 11(4)(a), in turn defines drug to include cannabis. In the accusatory instrument, defendant's arresting officer made the following factual allegations. I observed the defendant driving a car, the key was in the ignition, the engine was running, and the defendant was behind the wheel. I know defendant was under the influence of drugs because I smelled an odor of marijuana coming from the defendant's clothing. I observed that the defendant had watery and bloodshot eyes, and I observed that the defendant had ash containing marijuana on his pants. The defendant stated, in substance, I had 2 puffs of marijuana before you stopped me. I know that the ash I recovered contains marijuana based on my professional training as a police officer in the identification of marijuana, my prior experience as a police officer making marijuana arrests, and the odor emanating from the substance. I advised the defendant of his rights regarding the taking of a test to determine the presence of drugs in his urine, and the defendant refused to take the test. At defendant's arraignment, the prosecutor submitted to the court and defendant, among other materials, a document entitled Report of Refusal to Submit to Chemical Test. In that report, the arresting officer alleged that he observed defendant change lanes twice without signaling and that defendant appeared unsteady on his feet after stepping out of his vehicle. Defendant moved to dismiss the accusatory instrument as facially insufficient, arguing that the factual allegations do not establish reasonable cause to believe that he was impaired by marijuana. Criminal court denied his motion. Defendant subsequently waived prosecution by information and pleaded guilty to driving while ability impaired by alcohol in violation of Vehicle and Traffic Law, Section 1192(1), a traffic infraction not originally charged in the accusatory instrument, to resolve his case. On appeal, the appellate term rejected defendant's facial insufficiency claim and affirmed the judgment of conviction. A judge of this court granted defendant leave to appeal. As a threshold matter, like the courts below, we cannot consider the allegations in the report of refusal to determine whether the accusatory instrument is facially sufficient. Facial sufficiency depends on the adequacy of the factual allegations contained within the 4 corners of the accusatory instrument, and a court may only consider additional documents if the accusatory instrument appends, references, or incorporates them. See People v. Hardy, People v. Slade, holding that a certificate of translation of the English language misdemeanor complaint was irrelevant to the facial sufficiency analysis because the complaint did not reference or incorporate it. Here, the accusatory instrument does not append, incorporate, or reference the report of refusal. Nor does the report of refusal qualify as a supporting deposition, accompanying or filed in connection with an information or complaint, CPL 120. Therefore, we must assess the sufficiency of the accusatory instrument based solely on the arresting officer's factual allegations contained therein. Turning to the merits, because defendant waived prosecution by information, we assess the accusatory instrument under the less demanding standard for a misdemeanor complaint. See People v. Willis, People v. Dumais. Under that more lenient standard, the factual part of a misdemeanor complaint must allege facts of an evidentiary character, CPL 100.15.3, demonstrating reasonable cause to believe the defendant committed the crime charged. Willis, quoting People v. Dumais, reasonable cause exists when evidence or information which appears reliable discloses facts or circumstances which are collectively of such weight and persuasiveness as to convince a person of ordinary intelligence, judgment, and experience that it is reasonably likely that such offense was committed and that such person committed it. CPL 70.10.2. A court may draw reasonable inferences from all the facts set forth in the accusatory instrument, People v. Jackson, where the factual allegations give a defendant notice sufficient to prepare a defense and are adequately detailed to prevent a defendant from being tried twice for the same offense. They should be given a fair and not overly restrictive or technical reading. As we confirmed in People v. Dondorfer, the standard that this court adopted in People v. Cruz for impairment by alcohol also applies to provisions of the Vehicle and Traffic Law concerning impairment by drugs. See People v. Dondorfer, decided February 17, 2026. Thus, the Cruz standard controls our analysis. Under that standard, a person is impaired when they have actually impaired, to any extent, the physical and mental abilities which they are expected to possess in order to operate a vehicle as a reasonable and prudent driver. As defendant concedes, an accusatory instrument need not allege erratic driving to provide reasonable cause to believe that a person drove while intoxicated or impaired. C.e.g., People v. Chatram, People v. Fiumara. Impairment may be discerned by observing the defendant's physical condition, the surrounding circumstances, and all relevant and reasonable inferences to be drawn therefrom. See Chatram. Applying these legal principles here, the arresting officer's factual allegations are sufficient to provide reasonable cause to believe that defendant drove while impaired by marijuana. The officer alleged that, based on his professional training as a police officer in the identification of marijuana and his prior experience making marijuana arrests, the ash he observed on defendant's pants contained marijuana. Moreover, defendant told the officer that he had taken 2 puffs of marijuana before the officer stopped him, and the officer smelled the odor of marijuana emanating from defendant's clothes. These allegations support the inference that defendant consumed marijuana inside the vehicle shortly before the officer approached him. The remaining allegations in the accusatory instrument support the conclusion that defendant was impaired by his recent drug use, a necessary element of the charge against him. The arresting officer observed physical manifestations of the effects of marijuana, specifically that defendant had watery and bloodshot eyes. Additionally, defendant refused a urine test to determine the presence of drugs in his system. Lower courts have consistently held that such refusal, when considered along with the other allegations in the accusatory instrument, is relevant to determining reasonable cause to believe that the defendant drove while intoxicated or impaired. C.e.g. Fiumara, People v. King. As these lower court opinions suggest, a defendant's refusal to take a chemical test evinces consciousness of guilt. Thus, based on the totality of the circumstances, there was reasonable cause to believe that defendant operated a motor vehicle while his ability was impaired by the effects of his marijuana consumption. To reach the contrary conclusion, the dissent looks at each relevant factor of impairment in isolation instead of considering them in their totality. For example, the dissent asserts that defendant's watery and bloodshot eyes, without more, do not bear on defendant's impairment because they are a common byproduct of allergies, among other benign causes. The dissent ignores that the accusatory instrument alleges more. It is the combined allegations of defendant's watery and bloodshot eyes, along with the remaining facts asserted in the accusatory instrument, that provide reasonable cause. Similarly, while defendants' refusal to take a urine test to confirm the presence of marijuana may be insufficient on its own to create reasonable cause to believe that defendant was driving while impaired, it is but one relevant factor. Viewed in the context of the entire accusatory instrument, defendant's refusal to take the urine test supports an inference that he was aware that he was driving while impaired by marijuana, and he did not want to strengthen the evidence against him. The logical endpoint of the dissent's isolated analysis of each of these factors is that on their own, they can never be probative of whether a person is impaired. The dissent tellingly cites no case law to support its view, nor any indication that its view is consistent with legislative intent. The dissent's claim that we condone the simple error of an officer's failure to the report of refusal to the accusatory instrument is both incorrect and a distraction from its flawed assessment of the accusatory instrument. Our analysis is grounded in the standards for facial sufficiency that the court has repeatedly reaffirmed over the course of decades, as well as the legislature's statutory definition of reasonable cause. The dissent ignores those foundational sources by scrutinizing each allegation in isolation and refusing to consider how they come together as a whole. It is apparent that the dissent's observations about each individual allegation goes to the weight that each ought to be afforded. But weight is a matter of proof for trial. See Willis, the truth of the allegations in an accusatory instrument is an issue for trial. It is not a basis for dismissing a complaint for facial insufficiency. See also People v. Smalls, observing that the court's rejection of the defendant's facial sufficiency argument did not preclude him from raising that same argument as a trial defense. Slade. The dissent's suggestion that under our analysis, a person may be charged with Vehicle and Traffic Law, Section 1192(4), based on the police observing them driving while their eyes are red, that they have a prescription bottle of Xanax in the cup holder, and that they refuse to take a blood test for Xanax, is particularly odd. In any facial sufficiency analysis, a court must consider all of the allegations in an accusatory instrument together. All we conclude on the record before us is that the accusatory instrument charging defendant established reasonable cause to believe that his ability to drive was impaired by marijuana. In any event, the dissent's Xanax hypothetical demonstrates perfectly why each case depends on the totality of the allegations. Xanax has many common side effects that could impair a person's ability to drive, including clumsiness or unsteadiness, difficulty with coordination, tiredness, and trouble concentrating. Mayo Clinic, alprazolam, oral route. The dissent's response to this point is further evidence that it misapplies the proper legal standard. The question is not whether watery, bloodshot eyes necessarily support reasonable cause to believe that a person is impaired by one drug, but not another. Whether there is reasonable cause to believe that a person's ability to drive has been impaired by marijuana or any drug listed in Public Health Law Section 3306(c)(1 is necessarily a fact-specific question that turns on the allegations in the particular accusatory instrument. Contrary to the dissent's framing, the same facial sufficiency analysis applies in any case where a defendant is charged under Vehicle and Traffic Law Section 1192(4), regardless of the drug they are alleged to have used. Defendants' arguments are similarly unavailing. Defendants claim that taking 2 puffs of marijuana is insufficient to establish impairment, ignores that the standard for impairment under Cruz is whether someone is actually impaired to any extent and not some minimum amount of drugs consumed. At this stage, we are concerned with the sufficiency of the instrument under the minimum standard of reasonable cause, which asks whether the entirety of the factual assertions and the reasonable inferences that follow from them make it reasonably likely that the defendant committed the charged offense. CPL 70.10, C. Willis, Jackson. Applying that standard here, we conclude that the arresting officer's observations of defendant's appearance, the surrounding circumstances, the officer's training and experience, defendant's admissions, and defendant's refusal to take a drug test, considered together, provide reasonable cause to believe that defendant drove while impaired. The allegations are collectively of such weight and persuasiveness as to convince a person of ordinary intelligence, judgment, and experience that it is reasonably likely that defendant was driving while ability impaired by drugs, as charged in the accusatory instrument, CPL 70.10-2. Thus, the accusatory instrument served its purpose of providing defendant with notice sufficient to prepare a defense and avoid being tried twice for the same offense. See Willis, 44, and Y3D at 21. Accordingly, the appellate terms order should be affirmed. Order affirmed. Opinion affirmed. Opinion by Judge Rivera. Judges Garcia, Singas, Canataro, and Halligan concur. Chief Judge Wilson dissents in an opinion in which Judge Troutman concurs. Decided February 17, 2026.